Morning, all you Zoomers out there. My name is Mark Kozar. With me is my colleague Stan Walowski. We're going to talk about updates on the liquor code and liquor law here in Pennsylvania. We're going to kind of break it up into three different subsections, kind of pre-COVID, things that happened prior to mid-March, late March, things that have happened since we've been under the COVID disaster emergency declaration by the governor, and kind of post-COVID stuff, things that we're looking at that might be happening after the disaster emergency has been terminated. We're going to start with the pre-COVID things. The board has come up with a new policy with respect to contiguous serving areas. The prior policy of the PLCB had been that so long as the licensed areas, seating, serving, storage, kitchen, were contiguous, the PLCB would issue a license. The board's new policy, and good luck finding where it's been written, is that they're requiring all serving areas, that is the seating areas, customer accessible areas, to be contiguous. This means that you can't have an intervening unlicensed storage or kitchen area between two seating areas. And this could be an issue for a number of licensees going forward and perhaps current licensees. We all know about the 400-foot rule. It's contained in section 1-102 of the PLCB, or the statutes. Requires 400 square feet equipped with a kitchen and table for at least 30 customers. The 400 square foot requirement used to include, in addition to seating, storage and kitchen areas. Now the PLCB policy is that the licensee must have 400 square feet of seating, i.e. serving area, excluding storage and kitchen areas. Interestingly enough, the PLCB's new policy is contradicted by their own license compliance program guideline, which defines the 400 square feet as, quote, the licensed premises. So that's something to keep in mind with respect to future licensing. We don't know what they're going to do about locations that currently have seating areas that are not contiguous. Hopefully they'll grandfather those things in. Another thing that has come up is that with respect to grocery stores and convenience stores, is that the kitchen doesn't have to be on licensed premises if the unlicensed / licensed premises are in the same building, so that the kitchen can be on the unlicensed premises so long as it's all under the same roof. However, restaurant licensees still must have food available and stored on the licensed premises or available within the same building that has the interior connection to the licensed premises operated by the licensee, i.e. the same entity. I know we have some situations where we have clients that have two separate entities operating convenience store portion of the store and the licensed portion of the store. The board, I don't know what they're going to do with people who are already licensed, but going forward, that would be an issue. Again, a customer must be able to order food and receive the food while being on the licensed premises. Next topic is on-premise consumption policy, and my colleague Stan Walowski is going to speak to that.
Yes, thank you, Mark. The PLCB's current, and I'll say this pre-COVID position, is that if a restaurant licensee sells beer for takeout, that licensee must also sell beer for on-site consumption. And if the restaurant licensee has a wine expanded permit and sells wine for takeout, that licensee must also sell wine for on-premises consumption, or make it available, I should say. Make beer available for customers who want to just consume it within that restaurant seating area, or make wine available for customers who want to consume wine in that seating, restaurant seating area. Now, the PLCB's position, it's not that if a licensee sells, for example, 30 brands of wine for takeout, it must also offer a customer 30 brands of wine or 30 brands of beer for on-site consumption. But it has to, according to the LCB, if you're a restaurant licensee and you're selling beer for takeout, you're selling wine for takeout, you must offer at least one brand of beer, one brand of wine for a customer who wants to consume that beer or wine within the seating area. The LCB's position is that if a licensee is not a bona fide restaurant under the liquor code, unless that licensee sells the same type of alcoholic beverage for on-premises consumption that it does for takeout. However, the PLCB's position in this regard appears to be contrary to a fairly recent published Commonwealth Court decision. It was a Commonwealth Court decision from October of 2019. And as you may know, the Pennsylvania Commonwealth Court is the first level appellate court in Pennsylvania. And the Commonwealth Court hears all matters dealing with decisions of government agencies, appeals of decisions from government agencies. And if the Commonwealth Court enters a published opinion interpreting sections of the liquor code, that is law. That is the law in Pennsylvania. And in the case I'm talking about, that was the case of P&R Beverage Inc. versus Pennsylvania Liquor Control Board. And in that case, a nearby beer distributor objected to the transfer of a restaurant liquor license to a restaurant that was going to be located within a giant grocery store. One of the arguments that the beer distributor made before the Commonwealth Court was that the restaurant was not going to be a bona fide restaurant under the liquor code. And the beer distributor before the Commonwealth Court pointed out, in support of its argument, pointed out to testimony that a giant witness gave in the hearing before the Liquor Control Board. And the giant witness had testified that if the LCB had granted the license transfer, Giant would operate a restaurant within its grocery store, separate, distinct, and apart. And the restaurant would sell food for takeout, for on-premises consumption. It would sell beer for takeout, beer for on-premises consumption. It would sell wine for takeout, but it would not sell any wine. It would not offer any wine for on-premises consumption. And the witness for Giant also testified that he estimated that 98% of the beer sales would be for takeout and only 2% would be for on-premises consumption. So in front of the Commonwealth Court, the beer distributor argued that the restaurant inside the Giant grocery store would be a sham restaurant because 98% of the sales, beer sales, would be for takeout. Only 2% would be for on-premises consumption. And it was also going to be a sham restaurant because even though it was going to sell wine for takeout pursuant to a WEP, it was not going to allow any customers to consume wine within the seating area. However, the Commonwealth Court rejected that beer distributor's argument. The court held that Giant, based on the testimony, Giant would operate a bona fide restaurant under the liquor code because it would have seating for 30 and it would sell prepared foods for takeout and for consumption within the premises. The Commonwealth Court held that the Giant restaurant was a bona fide restaurant under a liquor code, even though it was not going to sell wine for on-premises consumption, even though it was going to sell wine for takeout. So it would appear that the PLCB's position is in conflict with that Commonwealth Court decision. But, unless a licensee challenges the LCB's position, which is also now the position of the Bureau of Liquor Control Enforcement, if a licensee, grocery store, convenience store, is selling beer for takeout, it must sell beer for on-premise consumption, and if it sells wine for takeout, it must sell wine for customers who want to consume it within the seating area, and if it doesn't do both, doesn't offer both, it will be issued a citation. Mark?
I just want to follow up on what Stan was talking about. The BLCE can cite a licensee as being not a bona fide restaurant for failure to provide beer and/or wine for on-premise consumption. We've been told that the BLCB has issued citations for failure to serve beer or wine for on-premise consumption, but it is our understanding that those citations were also related to, in addition to a lack of seating or a lack of food. And so the citations that the BLCE has issued weren't solely for the fact that the licensee wasn't selling beer and or wine for on-premise consumption. There was another deficiency that led them to write the licensee up for not being a bona fide restaurant. We have yet to hear, and if any of you have received a citation for failure to provide on-premise consumption of beer and or wine, please let us know, because we're not aware of any such citation solely for that fact.
But with that said, that's what the Liquor Control Board's position is.
Yes.
And the BLC's position. Yes.
We're going to move on to the PLCB's license compliance program. It came into law via Act 44 of 2017, which oddly enough was an amendment to the fiscal code. Act 44 authorized the PLCB to administratively suspend the liquor license of a licensee who no longer meets the seating, square footage, food, health license, or health license for a licensee. In other words, a PLCB employee could walk into the licensed premises, see that you don't have 30 seats. They can just reach over and pull your license off the wall and essentially shut down any alcohol service. It doesn't mean you couldn't still serve food. So it's an immediate suspension of the license. The board must provide the licensee with notice of the exact deficiency. Now, it's interesting because this isn't something the BLCE can do. They could cite you for not being a bona fide restaurant, but they can't go in and pull your license off the wall and suspend it. These administrative suspensions remain in effect until the licensee can establish to the board's satisfaction that the licensee is compliant with the liquor code. Now, these administrative suspensions can be appealed, and that appeal goes directly to the Commonwealth Court, which has a limited period of time in which they must hear the appeal and render a decision. The next thing we're going to talk about is the evolution of the 192 fluid ounce limit on takeouts. There's been changes in policy numerous times over the years, and Stan is going to enlighten us as to what those former policies were and what the current ones are.
Let me first start out by saying that sections 401A and 407A of the Liquor Code contain similar language. Both sections state that restaurant licensees may sell malted brewed beverages for consumption off the premises where sold in quantities of not more than 192 fluid ounces in a single sale to one person. So that statutory language begs the question, what is a single sale of malted brewed beverages to one person of 192 fluid ounces or less? Or the other side of that coin is, what is a single sale to one person of 192 fluid ounces of beer or more to one person in a single sale? Well, as Mark alluded to, over the years, the Pennsylvania Liquor Control Board, Office of Administrative Law Judge, the Pennsylvania Liquor Control Board itself, and also the Bureau of Liquor Control Enforcement have reached somewhat different interpretations as to what is a single sale to one person of 192 fluid ounces of beer or less. So back in 2001, when I was an attorney for the Pennsylvania State Police Bureau of Liquor Control Enforcement, I brought a citation case against a licensee in Mercer County. And one of the charges was that that licensee sold malted brewed beverages in excess of 192 fluid ounces in a single sale to one person for consumption off the premises. And in that case, the administrative law judge who heard the case was Roderick Frisk. And incidentally, Judge Frisk is still an administrative law judge. Judge Frisk found a violation. And in finding a violation, Judge Frisk stated that in determining whether there is one sale or two sales to a single person of malted brewed beverages, that the focus on the analysis is on the transfer of consideration and the transfer of the malted brewed beverages. What Judge Frisk stated was that if a customer approaches the bar, the counter, with 4 6-packs, and if the customer puts 2 6-packs up on the counter, pays for those, just for those 2 6-packs, and those 2 6-packs are rung up and receives change or a receipt, the customer then puts them down on the floor, and if that customer puts 2 other 6-packs of beer on the counter, on the bar, the licensee's employee, same thing, rings them up, takes the money, rings them up, then gives them to the customer, and that if the customer then walks out with the 4 6-packs, Judge Frisk held that, no, that was 2 individual sales of 192 fluid ounces or less. And Judge Frisk stated that it is immaterial or irrelevant how much beer is actually carried out of the licensed premises. And as I said, I brought that case, and that was the position of the Bureau of Liquor Control Enforcement for years. However, the Pennsylvania Liquor Control Board had reached a different sort of interpretation or analysis. The position of the Pennsylvania Liquor Control Board is that it is material and it is a determining factor how much beer a customer carries out of the premises of the building. And it is the Bureau of Liquor Control it is the Pennsylvania Liquor Control Board's position, which I'll get to in a minute, is also now shared by the Bureau of Liquor Control Enforcement, that if a customer has 2 6-packs, puts them on the counter, the bar, pays for them, puts them down, takes 2 more 6-packs, puts them on the counter, another second transaction is rung up, that if the customer walks out with the 4 6-packs, that's a violation, that is a single sale of 4 6-packs. And as I said, the Bureau of Liquor Control Enforcement has also changed its policy. In 2018, it cited a licensee convenience store for selling more than 192 fluid ounces of beer in a single sale to one person. And as I said, it was in the context of a convenience store. And this convenience store inside the building had two areas. It had a licensed area and it had an unlicensed convenience store area. And the separation between the licensed convenience store area and the unlicensed convenience store area also went right through the counter, the service counter. So in a sense, one cash register was located on the licensed area and another cash register just a couple feet away was located on the unlicensed area. Well, an undercover Bureau of Liquor Control Enforcement officer went into the convenience store, got 2 6-packs, put them on the counter, paid for the 2 6-packs, took the 2 6-packs, and then he put them on the other side of the counter, which was the unlicensed counter of the convenience store. That enforcement officer then goes, gets 2 more 6-packs out of the cooler, comes back, it's 30 seconds later, puts those 2 6-packs on the counter, the employee of the convenience store in the licensed area rings them up. The enforcement officer then takes those 2 6-packs and then takes those 2 other 6-packs that you just purchased, no less than a minute ago, walked out with the 4 6-packs. And based upon that, the Bureau of Liquor Control Enforcement cited that licensed convenience store for selling more than 192 fluid ounces of all the brewed beverages in a single sale. However, the administrative law judge dismissed that citation. The administrative law judge said that it was no violation, that because the customer, the undercover enforcement officer, after the first sale of the 2 6-packs, put them on an unlicensed area and then purchased 2 additional 6-packs in a subsequent sale. That was 2 separate sales of 192 fluid ounces or less, and there was no violation. The administrative law judge held that the customer does not have to actually leave the building. So that is the, current state of the law, which is still, I think Mark will agree, somewhat ambiguous, somewhat gray.
Well, Stan, what would you say is the best practices for our members here at PFMA?
Well, I don't know. I guess it maybe is on a continuum. On the one end of the continuum, if you want to be 100% sure that you're not going to receive a citation if the customer comes up to the counter that wants to buy a beer for takeout, the customer should only be allowed to bring up 192 fluid ounces or less. You ring that up as one sale, and then you ask the customer to actually leave the building and then come back empty-handed. That's the 100%,
you'll never get cited.
You'll never get cited. However, I think, though, as I said, if you want to challenge it or you want to push the envelope, and I think it's you have a good argument if you want to challenge it, push the envelope, is at least have the customer walk off of the licensed area, and then even if it just steps off, even if that the licensed area from the unlicensed area is just a matter of a few feet away, have them step off with the 2 6-packs, and then he could come back onto the licensed area with the 2 6-packs and then buy 2 more. I think that's defensible too. But all right, Mark.
Okay, we're going to move on now into policies and legislation that have come forward via the COVID disaster emergency. There's been a lot of changes, some temporary, some permanent. We're going to kind of walk through those. Obviously, the governor issued a COVID disaster emergency on March 6th of this year. And as part of that, they set up a red, yellow, and green phases for counties across the state. We won't talk about red because there are no counties in red anymore. Yellow phase, those counties, if you're in those counties, as you already probably know, you can be open to sell food and beer to go and also wine to go if you have a WEP, but there's no on-premise consumption or seating. Another thing that would go along with this that ties into this that I'll talk about later, but just wanted to drop it in now, has to do with mixed drinks to go. And I'll talk about that a little bit more in depth. Most of the state is now in green phase. This means that you can have on-premise food and alcohol consumption. However, there are a number of limitations to that. The first limitation is that with respect to seating, you can only have 50% of your fire code maximum capacity, or 24 people for every 1,000 square feet of licensed premises. The caveat to that is that you must maintain 6 feet between parties at tables. A lot of people read this to mean 6 feet between the tables themselves. It's actually 6 feet between the back of a chair where a person's sitting to the back of the chair of the next table, which really is much more than 6 feet between the tables. So that, quite frankly, a place might be permitted to have 50% of their fire code maximum capacity, but because of the physical restrictions of the location and the need to have 6 feet between parties at tables, you might end up with maybe 30% capacity. In addition, the green phase permits bar seating with physical distancing. We're also tired of hearing the term social distancing, but quite frankly, it works. There's a caveat to that you can have a maximum of 4 customers that have a common relationship that can sit together at the bar. So for example, if Stan and I and our colleagues, RJ O'Hara and Paul Namey, went out to a local pub to have a ginger ale together, we could all sit together at the bar without being 6 feet apart. Face masks in green phase are required for entering, exiting, and using the restrooms or moving anywhere around the licensed premises when not seated at your table. There are a host of other requirements regarding cleaning and other specific issues. We won't cover them all. However, a full list of these requirements and suggestions can be found in the Governor's Guidance for Business and Restaurant Industry, updated June 17th. That can be found on both the Governor's webpage and the PLCB website. It goes into very minute detail on how you have to clean the tables and masks for service personnel, those types of things. Quite frankly, because most people are in green, I'm sure you're doing all those things to keep yourselves and customers safe. The next COVID-related policy that we've been tracking has to do with the pausing of renewal fees and safekeeping fees. On March 16th, the PLCB issued an email blast which has paused the payment of safekeeping fees and license renewal fees, and all related penalties will be waived. So in other words, if your renewal was due on the end of May, you don't have to pay it, and in the future when you do pay it, you will not have to pay a penalty for late payment. We expect that this is going to last until sometime after the governor rescinds the COVID disaster emergency and some remediation period thereafter. If I've watched the news correctly, I believe that the COVID disaster emergency was declared on March 6th of this year for 90 days. It would have expired June 6th. The governor has reissued it for another 90 days, which is going to take us till end of September. So we will be living with these things until that time. So even when the COVID disaster emergency has ended, the PLCB has indicated there will be a mitigation period in which you will be able to pay the safekeeping fees and or renewal fees without incurring late fees or penalties of any type. Another policy which came out of the COVID disaster emergency has to do with the temporary extension of premises. Some of you out there may have already done this. On June 3rd, the PLCB issued an email blast which introduced an expedited process for the temporary extension of premises for outdoor seating areas only. The extension area must be immediately adjacent to, abutting, or contiguous to the existing licensed premises. You can't license an area across the street. Again, we have to look at contiguousness for this extension for outdoor seating. The application process is through PLCB Plus website. There is no fee for a temporary extension of premises. However, you must submit a plan to the board showing the area to be licensed. That is a requirement. The application receipt, which you print out, is the licensee's authority to use the outdoor seating area that has been applied for. The PLCB at some point in time after the application is issued or applied for, the PLCB will send out a placard to be posted by the licensee. This is a temporary extension for outdoor seating. It will expire when the governor ends the current public health emergency. If you have applied for it and are utilizing a temporary extension outdoor seating area and you want to make it permanent, you need to file a extension of premises for a permanent extension. That application is through PLCB Plus. There are fees with that and a 30-day posting period. My suggestion is if you have a temporary outdoor seating area at this point in time and you think, you know, I'd like to keep this, it makes sense, it makes good business sense, I would advise you to file for a permanent extension for that same area as soon as possible. Again, because there's the 30-day posting period upon which you won't receive approval until after that 30-day posting period. The next policy change that came about because of the COVID disaster emergency has to do with final inspections. PLCB agents are not permitted to make on-site inspections during the COVID emergency. The PLCB has agreed to accept photos in lieu of an on-site inspection. We have done a number of these. We've kind of instructed clients on, okay, this is what you need to take a picture of: the seating area, food storage area, showing that you have food for 30 on your premises. A copy of the health permit also needs to be supplied to the agent. But the PLCB, the bottom line is the PLCB will accept photos in lieu of a final on-site inspection by a PLCB agent. The next thing that has come about because of the COVID disaster emergency has to do with cocktails to go. Excuse me. On May 21st, the governor signed House Bill 327, which is now known as Act 21 of 2020, which makes significant but temporary changes to liquor distribution. It permits certain licensees to sell prepared beverages and mixed drinks to go to non-licensees, and in some circumstances to other licensees. The definition of prepared beverage and mixed drink is that it is a sealed container holding between 4 and 64 ounces of liquor and mixer prepared on the licensed premises by the licensee. Some things that are not covered under this are you can't buy a shot to go or a mixed drink that contains both beer and wine. It's limited to restaurant and hotel licensees who have lost at least 25% of their average monthly sales due to the restrictions imposed by the COVID emergency declaration, who are offering meals to go. If you are not offering meals to go, then you cannot take advantage of the cocktails to go. Again, a meal is defined in section 406. It is food sufficient to constitute breakfast, lunch, or dinner. It doesn't include snack foods like peanuts, pretzels, those types of things. There is no limit on the number of mixed drinks that can be purchased by a customer, which is kind of interesting. There are a number of limitations. Within 60 days, the licensee must use a transaction scan device to verify the age of anyone who appears to be under the age of 35. Within 48 hours of opting to sell cocktails to go, licensee must post signage warning customers that it's illegal to have an open container of alcohol in a vehicle. Signage must also state that mixed drinks are open containers and must be transported in the vehicle's trunk or other part of the vehicle that is not occupied by the driver or passengers. As a side note, we've prepared these types of notices. If any of you would like a copy of those notices, please feel free to email either Stan or myself. Other limitations are the hours of sales for cocktails to go. The hours are 7 a.m. to 11 p.m. Monday through Saturday, and 9 a.m. to 11 p.m. on Sundays. Now, containers with openings for straws or sipping holes must be covered. In addition, a licensee may not deliver a cocktail to go. However, curbside delivery and payment of cocktails to go are permitted without a transporter for hire license. And we will get into that whole transporter for hire license, curbside delivery in a little bit. It's quite the hodgepodge of policy and legislation. A hotel or restaurant licensee who's taking advantage of the cocktails to go are permitted to sell to other restaurant or hotel licensees. Such sales must be reported to the PLCB in writing within 7 days of the sale. This program, again, will end when the COVID disaster emergency ends and following a mitigation period where licensee is operating at less than 60% of its seating capacity. Now, that's kind of an interesting number, 60% of the seating capacity, because under the green phase, licensees are only permitted to have 50% of seating capacity. So it looks like licensees will be able to sell cocktails to go until the COVID disaster emergency ends, period. Another piece of legislation that has come down during the COVID disaster emergency, although not directly related to the COVID disaster emergency, was House Bill 1048, which the governor signed into law on June 5th. It is now known as Act 29 of 2020. It becomes effective August 4th and has to do with, I don't know the best way to describe this, licensing unlicensed cash registers in licensees' buildings that are under 11,000 square feet with the same operator. It's an interesting piece of legislation, and quite frankly, it may lead to future legislation. Obviously, this affects very small grocery stores and convenience stores. We'll talk a little bit later about how this may be opening a door to front-end cash register usage by grocery stores in the future. For our purposes, Act 29 eliminated, kind of at long last, the liquid fuel prohibition, which you all know we've been fighting for how many years, Stan? 15 years now?
Yes, many, many years.
We spent a lot of hours in litigation over the liquid fuel prohibition, and we're not going to miss it.
That's for sure.
It also eliminated the need to obtain PLCB approval for interior connections between licensed and unlicensed premises where liquid fuels are sold, which is kind of a, when I first read this, I really kind of passed over that section, and as I've been rereading it, I realized how important this is, because now it seems like, and Stan, correct me if you think I'm wrong, that you really don't need to say, hey, board, I want approval of this interior connection because I'm selling gas over this cash register.
Now, Mark, is that just for buildings?
11,000 square feet or less. All these provisions apply to buildings of 11,000 square feet or less. So if you have a building of 11,000 square feet or less, and you have for example, 3 cash registers, and one of them you have unlicensed, because that's the cash register where gas has been rung up, you can now request that cash register be deemed unlicensed premises. And you have to comply with a number of items. One is that you have to have, it has to be in the same building as licensed premises. The same entity needs to own that cash register and the other cash registers. There must be signage designating that alcohol could be purchased at that register. No self-scans are permitted. Registers must be staffed at all times when patrons are purchasing alcohol. The way I read that, and again, Stan, correct me if I'm wrong, is that if somebody walks up to a cash register with a bottle of wine, then a ramp-trained person over 18 must go over to the cash register and ring them up. It's not like the person, the clerk has to be standing at that cash register all the time, waiting for somebody to show up with a 6-pack of beer or a bottle of wine. Transaction scan devices must be used at this cash register when customers appear under 35 years of age. You need to notify the PLCB with a notice of compliance that you are complying with these above requirements. Once notice is provided to the PLCB, the register is deemed to be licensed. We expect the PLCB, and we got an email to this effect the other day, we expect the PLCB will shortly be issuing guidance regarding the form of the notice of compliance. We've actually been in the process of preparing compliance letters for clients, and we're going to hold off on sending those in to wait and see if the PLCB actually issues a form or some type of guidance on what absolutely has to be in the letter. We know that the letter must state the square footage of the store and that it is less than 11,000 square feet, that you're going to have the signage, that no self-scans are permitted, the register will be staffed, clerks are 18 and ramp trained, and you're using the transaction scan device. And of course, you're going to have to append to whatever type of form the PLCB comes up with, or a letter, a copy of the floor plan designating or showing where that particular cash register is, that you would like to be deemed to be licensed. Again, we're waiting for a little bit of guidance from the PLCB before we inundate them with compliance letters to see if they're going to issue a form or issue some type of guidance as to the content of the letter. We now moving to what we're calling post-COVID type of things. One of the areas that Stan and I and our other PA attorneys here have talked about extensively has to do with curbside delivery of alcohol. And right now, it is a crazy hodgepodge. For example, it's fundamentally illegal to do curbside delivery of beer unless the licensee has a transporter for hire license. And that would include an employee carrying a six-pack out to somebody's car. That the entity would have to, the licensee would have to have a transporter for hire license to be able to do that legally. Again, going back to the mixed drinks to go, that statute specifically provides that you can do curbside delivery and payment for the mixed drink. No transporter for hire licenses is needed. Transporter for hire licenses aren't available for wine. So under no circumstances.
Well, you should say, Mark, I mean, transporter for hire licenses would be available for wine, but they're almost like meaningless because the customer has to actually walk into the premises. So, you know, the restaurant area of the convenience store or grocery store, or whatever, purchase it.
Yeah, the sale has to be made.
The sale has to be made, purchase it there, because under the statute, yeah, the customer must be inside, and you know, if they appear to be 35 or younger, they have to, their license has to be scanned. And the PLCB's position is, no, you can't order like wine over the phone or over a website and have it delivered. The customer has to actually walk in and purchase it. Now, I guess, Mark, and as I said, it's somewhat meaningless if the customer goes in and purchases 4 bottles of wine, and if that licensee has a transporter for hire, the customer could say, hey, you know, whatever, I just had surgery or whatever, I can't carry this out. Could you have somebody carry it out to my car? And if the licensee has a transporter for hire, the specific type that allows for transportation of wine, yeah, they could.
Right.
But for all practical purposes, yeah, you know, as I said, it's you can't have the technical curbside delivery of wine.
So in essence, what we have today with respect to curbside delivery is you don't need a transporter for hire license to deliver mixed drinks. If you have a transporter for hire license, you can deliver beer curbside.
But this transaction still has to occur inside, meaning the customer has to call ahead and provide their credit card information, and the licensee has to ring it up before the beer actually leaves the building, right?
Exactly.
But wine, no, for wine, there's no.
There's really a legislative impediment to being able to do that, even if you have a transporter for hire license. I mean,
yeah,
because the sale has to be made on licensed premises. Our hope is that either the PLCB or the legislature will pass regulations or legislation to treat all types of alcohol the same, because as I said before, this is a hodgepodge, and you have to be very careful about what you're taking out to and delivering to a person's vehicle curbside, particularly if you don't have a transporter for hire license. Could be problematic. This kind of ties in with off-site delivery. Again, you know, it could be done for beer if you have a transporter for hire license. It can't be done for wine, and specifically, you can't deliver a mixed drink to go. So again, we have another situation where all three types of alcohol are treated differently, kind of in a nonsensical fashion. Last but not least, and we believe that some of these policies and legislation that have come into being are going to kind of open the door for future legislation or perhaps regulation. We think that the Act 39 perhaps has opened the door for the fact that for future legislation that would permit all grocery store front-end cash registers to be used to purchase beer and wine. That remains to be seen. You know, when you look at how the liquor code has progressed over the years, it's been in incremental steps. It hasn't been in open the barn door and let all the cows out. It's been let one cow out at a time and see how it goes, and then slowly but surely keep opening the barn door. So we believe these incremental changes that have been made because of COVID and during the COVID emergency might lead to more less restrictive legislation or regulation in the future. Stan, you have anything else to add?
No, Mark, and I agree, because it does seem these rules where beer, wine, and distilled spirits, mixed drinks are treated differently. There appears to be no logical, rational reason why. For example, I can call a restaurant or grocery store that has a transporter for hire license, or that has a company that has a transporter for hire license that's doing their deliveries, and say, order 2 6-packs of beer. I give my credit card over the phone and I order, say, a pizza, and they bring the 2 6-packs of beer to my home. But yet I can't do that for wine. Why? You know, I mean, if you're talking about public welfare, health, and safety, I could get just as inebriated drinking 2 6-packs of beer as I can, a bottle or a half bottle of wine. So why are you treating, as I said, beer differently from wine?
Yeah, and the other thing that's really interesting is that, until a month ago, it was never permitted to have a mixed drink to go.
Yeah.
And now you can get mixed drinks to go, and they can be delivered curbside, and you can pay for it curbside.
But yet, why can't I pay for curbside beer or wine?
Exactly.
Give me that, rational, logical reason why you're making these distinctions. And there is none. There really is none. Not from a public welfare, health, peace, and morals point of view. As I said, you give me you allow me to get a mixed drink curbside to go, but yet I can't get a growler of beer curbside to go, unless there's a transporter for hire license. So,
well, we're almost out of time here. Actually, we had intended to leave a little bit more time for questions. So if anybody has any questions, feel free to ask them if that's a possibility.
Yeah, thanks, Mark and Stan. I appreciate it. So there's a Q&A function at the bottom of your screen there, and that's where you can type in your questions.
Oh.
I'll give people a few moments to, if they have any questions, and then I'll ask the questions to you.
Okay.
Great.
Okay, we have a question that's in the chat. It's from Sandy Brown. What's involved in getting a permit to deliver beer?
Well, and that would be a transporter for hire permit. Stan, you want to?
Yeah, I mean, I think the nuts and bolts are, from what I understand, are fairly simple. I mean, you just go to the LCB Plus website. You know, you fill out the application. Now, what you have to do, though, is the vehicle, and maybe this is, you know, one of the, I don't know, harder things, maybe not, is the vehicles that deliver beer. Each vehicle that is going to be delivering beer pursuant to that transporter for hire license has to have signs on both sides of the vehicle. Okay, and they could be these magnetic signs that you take off, or you could paint them. And I think what, Mark, the letters have to be at least 4 inches high.
That's correct.
And you have to state the name of the transporter for hire licensee, the transporter for hire license number.
And I think the LID number too.
Yeah, yeah, you're right. But other than, I mean, yeah. So if you do that, and then it's just going on and applying. I mean, there's really no investigation, right, Mark? From what I understand, there's no like on-site investigation. No LCB agent goes to the so-called transporter for hire or premises.
The question popped up on the cost to apply for. I don't know the cost off the top
I'm
of my
not
head.
sure either. I don't think it's that much.
No, I don't think it's that much.
Maybe we're talking about several $100s, something like that.
And there's really no special requirements
Yeah.
other than the signage on the vehicle that's going to be doing the delivery.
Yeah, and the LCB is pretty lax as far as the vehicles. Like if you're a licensee and get a transporter for hire license, you don't, the vehicles that are going to be used to deliver beer could be your own vehicles. They could be that of an employee, as long as you enter into some, you know, agreement with the employee where the employee agrees that, yeah, they're going to allow their vehicle to be used for that. So yeah, as far as the vehicle, yeah, you could have an employee do it in their own vehicle, as long as you put those magnetic signs on both doors, both sides of the vehicle.
So a follow-up question to that was is it per company, store, or person, and what's the cost?
It's per company.
It's per company. So let's say I own the chain of grocery stores throughout Pennsylvania, and there are 100 grocery or convenience stores. I just need one transporter for hire license, and with that one transporter for hire license, I could deliver beer from each of those 100 convenience stores throughout Pennsylvania. Right, Mark?
That's correct.